Hello to all and hope you are doing well. In this video, the senior advocate of Supreme Court of India, Sudh Markandeji, will be discussing on the topic of law of medical negligence in India. On this, the first question is, how exactly would you define medical negligence, sir?
There is no codified law of medical negligence in India, so there is no definition in the sense that is understood in the enacted law, which usually contains, as you know, Section 2 is specific definition section in so many laws. But over a long time, the following elements have evolved as fundamental ingredients of medical and paramedical negligence. By paramedical, I mean like nursing and so on. So these are the elements. So there has to be a duty to care, and there must be a breach of such duty. Uh, so the third element is there has been a cause in fact, that is actual cause, something has happened. Then that cause is proximate cause. It's not remote. And then it has resulted uh, in damage, which is actionable. So these are the five elements of what we may call, medical negligence. So I may sum up in one sentence like this, that medical negligence is a breach of that degree of requisite care which is required of a doctor or a hospital that results in death, damage, or injury, and which is capable of assessment and compensation.
So, what kind of cases arises in medical negligence and in which form?
Cases of medical negligence can arise in criminal courts. If death occurs due to medical negligence, then it is punishable under Section 301, 304A, or under Section 337 for causing hurt or grievous hurt under Section 338 of the Indian Penal Code 1860. Medical negligence can also arise in a civil court or the Consumer Commission under the Consumer Protection Act, where compensation is claimed for negligence of a doctor or a hospital, whether private, corporate, or government. Many aggrieved persons also go to the permanent lok adalats constituted under the Legal Services Act 1987, which have fiscal jurisdiction up to 1 crores of rupees, seeking similar relief of monetary compensation. Some also file writ petitions, but to my mind, writ petition in the High Court is a singularly inappropriate forum or remedy, because the outcome of the cases of medical negligence depends upon the findings of fact, which have to be arrived at on the appreciation of documentary and oral evidence and expert opinion. So, in my view, writ petition is not an appropriate remedy, because of two reasons. It is ineffective, and there are more effective methods available in the fora of consumer disputes.
Yes,
Because
sir.
what happens is under Consumer Disputes Act, there is the definition uh, service. So this will come under deficient service, and if deficiency is found, then remedy is you will get a compensation or so on.
So, what is the approach of Indian courts in case of medical negligence?
Our courts usually follow what is called Bolan test. Bolan test was laid down in Bolan versus Free Rem Hospital Management reported in 1957, one weekly law reports 585 in England. It's the standard of ordinary skilled man exercising and professing to have special skill and not the highest degree of skill.
So has our Supreme Court given any advisory to the doctors?
Yes, indeed. In Martin F. D'Souza versus Muhammad Ishfaq, reported in 2009 3 SCC page 1, the Supreme Court has laid down the following broad precautions. That's their advisory, if I may use that expression. So, what the Supreme Court has laid down is that current practice, current, not obsolete, current practices, current infrastructure, current paramedical staff and other staff, current hygiene, current standard of sterility, all these should be strictly observed. Then second is that no prescription should be ordinarily given without actual examination of patient. Of course, this has been relaxed during the pandemic for the last 2 years. Then third is that doctors must make their own analysis, including tests and investigations, and that too with the consent of the uh, that too with the that too after matching it with the patient's version, and then doctors should not experiment on a patient except when it is absolutely essential, and that also with the consent of the patient. Then experts must be consulted in case of any doubt, and full record of the diagnosis and treatment must be maintained by the doctors and the hospital. India's medical science has evolved a lot. We already had, since ancient time, the Ayurveda. So, in my view, a code or medical code should be enacted by Parliament relating to everything, training of doctors, their uh, code of ethics, their everything should be at one place. I think we
Yes,
can have a longer discussion on this subject.
yes, sir. We can have a special discussion on this subject. And thank you, sir, informing all about the medical negligence in India. And that's all for the today.
Yeah, thank you very much.